Alex here with part 122 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the initial version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We go into my ex's attorney's opposition to my motion for order to show cause. This should be the updated order to show cause that I filed, and I can't even really remember what this one was about now, and that's not really a shocker to me given how convoluted the case is. The one thing I can say is, as with any opposition to motion for order to show cause that my ex's attorney files, and maybe even any attorney files, is the two go-tos are going to be, number one, okay, maybe I violated the order, but it wasn't on purpose. And then number two, I violated the order on purpose, but I had a reason for doing so. So I think that we're going to see something like that in this opposition to motion for order to show cause. But all of that being said, we aren't going to really be able to get into the details of it until we get started. So I'm going to go ahead and go into what I have filed. Here we have my ex's attorney's opposition to motion for order to show cause. Standard introductory paragraph. She indicates to the court that her client is represented through and by her, and that she is opposing my motion for order to show cause. Points and authorities. She says that the sole basis of the motion is that my ex... Okay, now I remember. So this is when she scheduled an appointment without giving me sufficient notice. She, Wait, what? She scheduled an appointment and gave me a 30-minute notice by email. What I forget is that I didn't forget this. I didn't forget having asked my ex to set an appointment as soon as possible. I just wanted notice of the appointment. And this is the thing that's really infuriating about these attorneys, is they are so brazen about trying to, for lack of a better term, gaslight you. Because this is something that I've said in the past in previous videos. One of the most frustrating things about the process is oftentimes victims going through the system have been subjected to narcissistic abuse, gaslighting, and all this other stuff. And then they go into the system, and then the judges and attorneys do it to them too. So all they're doing is doing the exact same thing that their ex was doing to them. And it just makes the situation 10 times worse. And in my opinion, it's one of the reasons why so many people are losing confidence in the legal system, in attorneys, and in judges. But anyway, part of this is gaslighting me. So she's making it seem like I'm the crazy person for expecting 30 minutes notice by a phone call or a text message, not by an email. When in reality, most people out there know that if you need to give somebody really urgent notice, you don't do it by email. You pick up the phone and call them. Or you can text, but a safer bet for 30-minute window would be a call. In any event, she's trying to gaslight, she's trying to convolute the issue, or confuse the issue, make it seem like I don't know what I'm talking about, or like I forgot something, when in reality, this is what they do. She's just employing her typical win-it-all tactics, win-it-all-cost tactics. That's a video, guys. And then if you're curious about this, please take a look at the video, How Attorneys Win, because what she's doing fits into that video. And it's very similar to the video How Abusers Win, but it's from the angle of how attorneys do it. It's similar but different, because with abusers, it's a more personal, intimate attack. With attorneys, it's kind of you don't matter, this is just how the business works. If you don't like it, screw you sort of approach. In any event, a dentist office notified, let's see here, defendant. So she must be my ex-respondent. But there was an opening, she took advantage of an earlier. Okay, so all of this is just a distraction. This whole thing doesn't matter. None of this is related to my complaint at all. or you could say it's a deflection. So she's trying to take the court off of what's the actual issue, and she's trying to point to all these other things where my ex is doing everything the way she's supposed to. She cites the standard law on contempt, which we've talked about numerous times. Now she's bringing up abuse of process, and I don't know if she's brought this up before. But abusive process is something that you're supposed to file a separate lawsuit for. So I'm not sure why she's bringing this up in an opposition to a motion. I have a video on this topic, guys. It's called abusive process, and it's a lawsuit for money damages. It's a claim for money damages, and it's not a basis to block a motion. It's a basis to, after the fact, recover attorney fees, costs, and special damages for having been subjected to the legal process. So you can't use it to just say, hey, stop everything here. You still have to actually win the actual issue, using whatever supportive defenses or arguments that you have. Prior to filing the opposition, my ex's attorney endeavored to work for a resolution suggesting the following language. So she's talking about things she proposed in other court. This is more deflection. She's just trying to distract the court again. I am making... What? Okay, so my ex is not the plaintiff, nor is she the petitioner. So this must have been put together really quickly because it's sloppy. In any event, what she means to say is respondent is making her best effort to work with a litigious co-parent in the raising of their child. My insistence on contact with her seems to be more for the purpose of harassing. That's not true. She says it though, because why not? It fits into the narrative that they've put together. Next we have email goes to my phone. No, it doesn't. I had a flip phone. Here's what okay, she's not mistaken. So an ordinary person will read this and they'll think, oh, okay, so she just thinks Alex gets email by phone. No, she knows that I don't. We've talked about this before. And here is what she's trying to do is later on, what she's doing is hedging. So later on, if the court blows up on her, she can say, okay, well, in the future, I'll call him. I didn't know he doesn't get email to his phone. So this here isn't sincere at all, in my opinion. I very strongly believe that the attorney, and for sure my ex, knows that I don't get email, and they just put that one sentence in there just in case they get called out so that they can claim they accidentally violated the court's order, which is one of the ways to get out of being held in contempt of court. That's a valid way to actually get away with it. So she knows what she's doing. It's as fast as leaving me a voice message. Ha ha ha, yeah, right. My goal is not an exchange of information, but to harass, blah, blah, blah. So this is the same stuff, more deflection. She's trying to get the court to pay attention to everything but the fact that I was given 30 minutes notice. I'm not even sure it was that little. I think I got more notice than 30 minutes notice. But in any event, I'm not going to go into that. The point is that there wasn't any time, there wasn't any notice, and that was on purpose. She did that on purpose. Counsel would submit my complaint is de minimis. What? And that I have looked for ways to find conflict rather than thinking, oh, okay. So here is what the attorney's doing again. She is trying to make it seem like conflict only exists when filings are put into the court system. What she doesn't realize is the conflict is continuing because of my ex's conduct outside of court. The filings are an actual symptom of the problem, but the attorney either doesn't care or doesn't understand that, or she's trying to exploit the court. So this is one of the things that attorneys do is they will find out what resonates with judges, and they will exploit those things, and they'll find ways to fit what you're doing into what appears to be into what the court thinks will appear to be what you're doing, knowing that that particular thing is a hot button issue with that judge. So this particular judge doesn't like filings, doesn't like court hearings, doesn't like any of that stuff. He wants parents to work it out. So what she's trying to do is she's trying to connect all of the conflict to me through my filings. So she's trying to take all of the negative things that her client is doing, all of the child abuse, all the neglect, all the conflict, and she's taking all of that and she's dumping it on me by trying to say, since he's the one filing papers, he's the reason all these things are happening. When in reality, the person filing papers is the person trying to rectify the situation, and that is the person trying to bring to the court's attention all of these things that are happening. Just because you take that element out of the equation doesn't mean any of those elements stop happening. They're still happening. It's just the court doesn't know about it because nobody's filing anything. And again, this is what I talk about in the video. End of filings is not end of abuse. This is one of the most common things that judges do not understand. I would say more than half of them do not understand this. And this is one of the things that most of us on this channel are going to have to figure out how to deal with when it comes to these particular judges. I am hearing now that more and more new judges understand what's going on because they're actually dealing with these different types of parents. And that's good. And that actually also fits into what I've said in the past, which is it's not really effective to train the existing judges in high conflict child custody. It's better to just get rid of them and replace them with other judges who actually do understand how it works. So whether they're being purged in elections, removed from the bench, or they're just retiring out, no matter how it's happening, as long as that continues to happening, as long as those judges continue to get off the bench and get replaced by judges who do get it, we should start to see a more positive swing, a movement in the correct direction. But in any event, I just want to mention that I am starting to get emails from people saying, hey, some of the new judges are way better, they understand what's going on, etc., which is good, because guys, that's what's going to work. Forget all the stuff about training. Just get the ones that understand what this is on the bench. And if there's any way that you can, impact your elections in your state, talk to people, talk to your friends, talk to your family about it. The best way to fix the situation is to replace the judges that are on the bench with new judges who understand what's going on. Not to train them, not to harass them with email. They don't care. Don't send them emails. Don't call them. Don't contact the legislature. Stuff like that. It's not going to do anything. What's going to work is actually switching them out. Moving down into the next section. We have here an affirmation pursuant to 239B, which is me indicating to the clerk of the court that this document, or no, that's my ex's attorney indicating to the clerk of the court that this document doesn't contain a social security number of any person. Certificate of service by mailing under Rule 5, indicating that she sent this document to me. It looks like she also emailed it to me, which is nice. By the way, guys, I don't have this email anymore. In fact, this account is closed as of years and years ago. So continue to send stuff to the proper person. Don't send stuff to these other emails. Here we have the motion opposition notice. Based on the checkboxes, she did not have to pay a filing fee. Here we have some exhibits. We have 3 different emails. Exhibit 1. All right, this looks like an exhibit we already went over. Maybe not, though. I'm going to start from the bottom. Hold on, guys. Let's start from the bottom. Okay, I'm going to start from the bottom, and if it seems like we've already gone through this, I'm just going to move on. Okay, did I get an email? Did my ex get an email from the dentist on an appointment? If you don't like the dentist, pick another one, schedule another date. Okay, so here I am mentioning that I'm missing the dental and vision card, so I remember going over this. I think I remember going over this. Anyway, let's move up. So she says she's told me over and over again that she doesn't have to... Okay, yeah, this is deja vu. Your dentist did contact, so she puts little quotation marks here. She's not going to contact them back. Her insurance doesn't cover them, which is why you can't just pick any one you want. Again, guys, this is the typical tactic. So number one, she doesn't tell me who is covered, and she doesn't give me the cards. And then in that same hand, she's like, first, I'm not going to give you the information, and then I'm going to make fun of you for not having the information. So it's like she tries to set herself up for being able to attack my character by not giving me the things that I need to actually be able to, come up with what it is that she wants. So in this case, she's like, make sure you pick a dentist that's in network. But by the way, I'm not going to tell you which ones those are. So, I mean, we've already talked about this, but this fits into the approach to the high conflict text. Send me info on what dentists are covered. So this is the logical response of a parent. Okay, if this dentist isn't covered, send me the info on which ones are covered. She's not going to want to send this information. And here I am even pointing out, if you keep dancing back and forth with this, I'm going to file a motion. And she doesn't care because she wants me to file a motion. This is the goal. This is one of the things that really frustrates me, because when it goes to court, they act like they're the victim because they're having to respond to all these motions. But they themselves actually want the motions to be filed, which is why they engage in conduct that triggers the filing of the motions. Again, guys, this is the stuff that judges who do not understand high conflict do not understand. Judges who do understand high conflict will pick up on this and they will take action. Next section here, she completely just ignores my last email, doesn't even address it, and says instead that I need to pay up front. So yeah, we've gone over this, guys. Maybe there's a new one up here, though. This is me saying I'm going to file... Okay, so I definitely went through this email already once before, saying I'm going to file a motion for contempt. And then here's her responding, saying she doesn't like to hear that kind of stuff because it's bad. And then, okay, so that's the end of it. So let's move on. Exhibit 2. Okay, yeah, I know I've gone through this before. These are the same emails. Yeah, I've gone through these before. It's like she just attached the same exhibits I did, which I don't know why she would have to do that. She could just refer to my exhibits. She doesn't need to attach the same exact things over and over again. Okay, anyway, going on to Exhibit 3. You need to give the address and phone number to make sure that they take the... Okay, so this is odd. This is new. So I do schedule an appointment with Dr. Molina, and her response is that I have to give the address and phone number, which is on Google, by the way. This is ridiculous. So I did. I could have said, hey, it's on Google. Or I could have said, hey, find out, just like she does to me, but I didn't do that. I don't fight fire with fire. By the way, I have a video on that topic. I don't have the email in here, but when she asked for this information, I remember just giving it to her. I just Googled it myself, copied it, pasted it. You know what would have been funny would have been for me to take a screenshot of Google and send her like the image of the screenshot. But, that's passive aggressive, so whatever. In any event, guys, the reason I think she's not opposing it here, whereas she was in the earlier email, because if you remember, she says, yeah, I got called by your dentist, but I'm not calling them back. What changed in this gap of time? I think I know what happened. At this point in time, I'm pretty sure that she has caused the procedure that the other dentist was trying to undergo, or sorry, that the other dentist was trying to perform on our son. She caused it to be aborted by entering into the surgery room. So they had like a sterilized room, and my ex went in there. They told her to leave. She wouldn't leave, and so they said, we need to abort the procedure because you're still in here. So anyway, she this is why things are different here. I think that that's what happened. And so on follow-up, they said that they wouldn't be able to treat our son. So then I went and got another dentist. And then of course, you can see here she's not getting in the way of that. I want to mention one other thing, guys. Sometimes when you're in the middle of all this craziness, you can get into the idea, oh man, this is so frustrating. It's a crazy custody battle. It's really a whole lot more than that. Crazy custody battles do not involve a parent going into an operating room while all the doctors are in scrubs with face masks on in a sterile room and not leaving when they're told to. That's not just a crazy parent. And I still, as I sit here talking to you guys, I still do not understand how a judge would not see this and go ballistic, because I would as a judge. There are certain things that normal people do, certain things that crazy people do, and certain things that alien creatures do. My ex is far beyond even that. I cannot imagine a situation where any parent would literally park their ass in a sterile operation room when their child is getting treated by doctors and not leave and cause and to cause it to be aborted, and then to cause them to say, we're not treating your child because of this. And this is just so, I just don't understand how this is not alarming to a court. And it ultimately, the judge does modify custody, but I think that this is a situation where the court shouldn't have been as passive as it was. Because if I wasn't as much of a pain in the ass as I was, this situation would not have been taken care of. 100% for sure. I need people to understand that had I not done anything, this situation would not have worked itself out. And I don't know if people know this, but my ex's teeth were all black. She has dentures by now, I'm sure. At the time that we were together, they weren't like that. But by the time this custody battle came up, they were. And they were rotten. And you need to understand that a parent who on their own has allowed their teeth to rotten to the point that they have dentures at the age of, I think she was like, let me think, around 29, 28. That's not normal. And it's like, what else do we need to do as parents to get this through your thick skull as a judge? Like, the reaction from the court is so... The only phrase that really fits it is that they're disconnected from reality. It's like they live in another dimension completely, and they just don't understand any of this stuff. And this is a different judge too. This isn't even the first judge. I want to reiterate that the judge does rule in my favor, and we will see that when we go to a hearing. But it's like, I can understand the judges being passive in most of these situations, but to me, this situation, a judge should be much more aggressive, much more active, and not just kind of just not even caring. Like, it's like they put the absolute bare minimum amount of effort into the best interest of the child. And it's so tough for me to come to these realizations and conclusions. But like I mentioned in previous videos, as I go through these documents, the memories start to rush back in, and I can give you guys more of a vivid sort of representation as to how I felt at the time than I could in any of my other high conflict child custody videos where I'm just going off of sort of the information that's kind of retained in my head. In any event, let's go on to the next document. We have here the declaration in support of opposition to motion. First paragraph here is that my ex, through and by her attorney, what is this? Submits a declaration in support. Oh, so I think I know what she did. She probably forgot to include her verification. Yeah, this is usually why attorneys do this. It's because they forget to include it in the actual document, so they have to include it as a supplement because it's a violation of law. Or actually, it's a violation of the court rules for them not to do this. So let's take a look here. We have a certificate of mailing under Rule 5, same thing as before. Index of exhibits, declaration by my ex. Did she say singed? Yeah, not signed, singed. All this stuff was put together really sloppily. Exhibit 1, declaration of my ex, and she's just declaring under perjury that the facts alleged in that opposition are true and correct. This is, I've talked about this probably like 20 times, guys, but local rules, and I'm sure other states have the same rules. In Nevada, local rules require the client, the attorney can't do this, the client has to do it. They require the client to sign and swear under penalty of perjury that any of the facts that are alleged in a briefing are true and correct. And the reason why is because those alleged facts are going to cause hearings to occur, and the court wants to make sure, number one, that there's an actual basis for the hearing, and number two, that if there wasn't a basis, then somebody can be called out as a liar and sanctioned for lying and causing that hearing to occur and causing everybody's costs to go up. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. My ex's attorney filed an opposition that was free and a declaration that was also free, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The opposition was very sloppy. It was rushed. I guess it makes me hesitant to put an hour into it. I feel like 30 minutes is appropriate for a document that was put together this quickly. I don't know, 45 minutes is probably better. Despite the fact that it was rushed, she would have still had to coordinate with my ex, get the emails, attach the emails as exhibits. So let's say 45 minutes for that opposition. And then the declaration that my ex signed, another 15 minutes. I mean, it's just a 2 or 3 page document, but that would have required some more coordination with my ex, getting her to come in, sign the paper and all that stuff. So we come to 1 hour in attorney fees for my ex, which at a rate of $250 an hour comes to $250 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.